What the heck is a trust, and is it something you should be thinking about when you're putting together your estate plan? My name is Alex Meeks. I am an attorney and the owner and founder of Acorn Law, a law firm that's dedicated to helping busy families get their affairs in order. So, this is a question I get a lot. I'll have potential clients come into my office and say, "Oh, my uncle or my buddy said that I should really look into having a trust, that it could be good for me." But a lot of times that's really where the knowledge ends, and folks aren't really aware of what a trust is or what it can do. So, this quick video, the purpose of it is to really just give the most basic and general idea. I will say at the outset, there are a lot of different types of trusts, and it really takes a nuanced look at your own personal goals and assets in order to determine whether any of these tools are a good fit for you. So just watching a video isn't going to be enough. You're going to need to really have a conversation with an estate planning attorney to have a real analysis of your goals in order to know, which of these might be a good fit. So I'm going to just in this video talk about the most common type of trust, and the one that I suspect mostly is the one that your loved one or friend is referencing when they told you you should get a trust. They're probably talking about a revocable living trust. So this is a trust that you set up during your lifetime to manage your assets so that they can pass smoothly at your death without needing to go through the process of probate. So let me break that down a little bit for you. First of all, a trust, what is it in its most basic form? It is really literally just a document. It's a document that creates this entity that can own assets. So, as a person, most people can own assets in their own name, real property, bank accounts, etc. You can own them in your own name. But a trust is not a person. It's an entity that can also own property. So that can be really handy in the right situation. When it comes to a revocable living trust, you would set this up during your lifetime, and you would retitle all of your assets so that they're in the name of your trust. So you wouldn't anymore have your bank account say, Jane Doe. It would instead, at the top of your bank account, when you get your statement in the mail, it would say the revocable living trust of Jane Doe. And that's how all of your assets would be titled. Your real property, etc., would all be in the name of your trust. And you, during your lifetime, are the trustee, typically, of that trust, meaning in essence that you during your lifetime continue to own and have all the same powers over all of your assets that you did before. You just kind of got this fictional entity that is owning those properties. But in reality, you're still the one pulling all the strings and making all the decisions. So why in the world would you want to do that if it's this big hassle to change the title of all of your assets? And you're still going to be making all the same decisions. Like, what's the purpose? So the reason why you do it is to save a hassle on the other end. So once you become incapacitated or you die, it can be really, if you don't have a trust set up, it can be really complicated and difficult for your family to go through the process of getting your assets all managed. And then ultimately, once you've passed away, to get your assets passed along to your beneficiaries, to whoever it is you want to get them. If you have a will and not a revocable living trust, then that will happen through a process called probate. Probate is where the court becomes involved and your personal representative shepherds all of your assets through the process, making sure they all get retitled into your estate, and then at the other end that they get pushed out to your beneficiaries. So if you have a revocable living trust, and if all of your assets have been retitled so that they're in the name of the trust, you don't need to go through that probate process. Instead, what happens is Like I said, during your lifetime, you would be the trustee and the one pulling all the strings and the one making all the decisions. But at certain triggering events, such as your death, your successor trustee, whoever you name, that person automatically steps into your shoes, and then they can be in charge of all those assets. So you can direct in your trust document how you want that all handled. That person can just seamlessly step into your shoes and distribute your assets all out to your beneficiaries without ever needing to get the court involved. So really, when it comes down to it, the reasons to have a revocable living trust in your estate plan is if you want to avoid hassle after your death, you want to avoid there being a court process, and if you want to have a smooth transition. In some states, probate is really, really onerous and in those or expensive. And in those states, most people will set up a revocable living trust plan. They'll be very, very popular. In other states, probate is not such an onerous process. It's not as expensive. And in those states, the decision is a little more of a personal one. Either way, it's really important that you speak with an attorney who can walk you through all of it. It's important that you think a lot about what you want your death to look like and how you want your family members to experience that process. Because once you have clarity on those things, then it'll be pretty obvious to you which way you want to go in your planning. So if you have any questions about this or any other estate planning topic, I hope you won't hesitate to reach out to me. I'm licensed in Maryland and New York, happy to speak with anyone. Love to talk to you, and I'd love to help.